Hello everyone, I'm Brandon McGee from the McGee Law Firm, and what I'm here to discuss with you guys today is the 8 costly mistakes that I see families making in their estate plan. And whenever I present estate planning information to groups, whenever I speak, do webinars, things like that, I always like to focus on the common mistakes that I see people making, because I think that's something that we can relate to. We can look and see, hey, am I making this mistake right now in my life with my estate plan? And so we're going to walk through those 8 common mistakes today. And if you're making some of them or even all of them, don't worry about it. Don't stress out. A lot of people are also making those mistakes, and I'm going to tell you what we can do about it. So a little bit about myself. I'm a DFW native, grew up in Dallas. I now live on the west side of the Metroplex. I have an office in Southlake and an office in downtown Fort Worth. However, I have clients all over DFW and even all over the state of Texas. And so I am an estate planning and probate and elder law practitioner. So what that means is that I'm not an attorney who's doing DWIs one week and bankruptcies the next week, and I dabble in estate planning. This is what we do at our office. It's what we enjoy. It's what we love. So day in, day out, we are estate planning, probate, and elder law practitioners. I'm also a member of a couple professional organizations that are very helpful for me and for my staff. One is the American Academy of Estate Planning Attorneys. The other is the National Academy of Elder Law Attorneys. And this gives me a great network of like-minded legal practitioners across the state of Texas and across the entire country as well. We're also a member of the Better Business Bureau. So let's start in with these 8 mistakes that I see a lot of families making. Mistake number 1 is families don't have protection to pass on their hard-earned wealth without government or court control. And what I mean is this: in the state of Texas, we have what are called probate courts, and the probate courts have 2 functions. Function number 1 is to help appoint somebody to liquidate and distribute an estate of a decedent. So after somebody passes, they have their home, their car, their bank accounts, retirement, etc. We need somebody to have the legal authority to go and sell the house, to get the money out of the bank, and to give it to the beneficiaries or the heirs. So the courts are there to assist with that. The probate court also exists in the event that that an adult loses their mental capacity. If an adult, maybe gets Alzheimer's or somebody has a bad stroke and they have some brain damage as a result, the probate courts will appoint a legal guardian to be that person's caretaker and decision maker in life. Okay. But it is 110% possible here in 2021 in the state of Texas to set up your estate to completely avoid the probate court system, okay? And I want you guys to know, too, if you're watching from another state or if you've lived in another state recently and you have some knowledge about these topics from that other state, keep in mind all 50 states have their own estate planning jurisdiction, meaning the laws in Texas can be different from the laws in all the other states and vice versa. So keep that in mind. Today we will be discussing Texas-specific law. Now, why should I avoid probate court? Why is it a mistake not to set up to avoid it? And number 1 is the expense. So I also help families through the probate court system, and I can tell you that it is always more expensive to go through the court system than to set up to avoid it. So you will end up spending more money at the end of the day, particularly if you have no estate plan. And then second, it is more time consuming. You're going to be waiting for months and months and months, depending on the situation, right? Probably anywhere between 3 months to a year or longer for the process to go through the court system. And a lot of times people get antsy, they get frustrated, they can't sell the house, they can't access some of the funds that they need to access. So it's stressful, it's time consuming, and it's more expensive, and it is well worth the effort to avoid having to go to court. Planning mistake number 2. So this dovetails off planning mistake number 1, and this is no documents for passing down assets or planning for mental capacity. And what I mean by that is that there are legal documents, and if we put the correct ones in place, these legal documents allow us to completely avoid court. So number 1, let's talk about this. Mental incapacity. If somebody has a head injury, if somebody is in a coma, if somebody has Alzheimer's, what is the solution to avoiding court? How do we avoid having to go to probate court to become that person's legal guardian? The answer is a series of documents called powers of attorney, okay? A lot of you have probably heard of powers of attorney. Some of you may have some or have had some in the past. But these are documents where we pre-appoint somebody to be our medical decision maker, somebody to be our financial decision maker, financial manager, property manager, in the event that we lose our mental capacity. So if something happens to me, if I'm in a terrible accident and I'm in a coma, my wife, who obviously does have powers of attorney over me, she can immediately go to the hospital and start making decisions. She can get my medical records. She can, access my financial resources. She can sell her house. She can sell my car. She can do whatever she needs to do, even though I'm out of it, okay? If my wife did not have those documents, she would be going and hiring an attorney like me, spending thousands and thousands of dollars to go through a court process. It's probably going to take at least 6 months. Again, it's called guardianship. So much cheaper, much quicker, much more stress-free just to have the powers of attorney to be able to avoid court if somebody loses their mental capacity. And a couple other tips on those. I recommend, number one, that they're relatively recent. I like my clients to stay within a zone of every 5 to 6 years to redo their powers of attorney. That because the laws will change, right? The legal language will evolve a lot of times because of lawsuits that are happening across the country. And what a bank or hospital may accept today, they may not accept in 4 or 5 years, 7, 8 years. We don't know for sure, but I like to have them redone about every 5 to 6 years. You also want those documents drafted by a lawyer, okay? I think that's very important to everything we're going to talk about today. Please use a lawyer. Please don't do things yourself, okay? And I kind of compare it to this. If my medical plan in life is to never go see a doctor, never have my blood pulled and analyzed, and I'm just going to if I feel bad, I may just get on WebMD, diagnose myself, and then go to Walgreens and buy some medicine. At some point, that's probably going to backfire for me, right? My health is probably I'm probably going to have a bad medical episode at some point if that's my whole life. And I never go see a doctor, never, get prescribed medicines, take medicines that I may need. It's the same way with legal documents. You really want an attorney, a professional who's trained to do them the right way. I have seen so many documents fail when people have tried to do them themselves, okay? But back to planning mistake number 2. So powers of attorney, that is how we avoid court if somebody loses their mental capacity. What about when somebody dies, somebody passes away? What are the different things that we can do? 4 different ways to get that person's assets. I realize these words are big: estate, assets. A lot of people think, look, that's not me. I'm not a multimillionaire. We all have an estate. We all have assets. Your home, your car, your checking account, your savings account, your retirement. Those are all assets. But when somebody passes, the ownership, the title to those assets, it needs to go from the deceased person to somebody else, the beneficiary, the heir, the spouse, the kids, whoever it's going to be. 4 different ways this can be done in Texas. I'm going to start with the worst way and work our way to the best. The worst thing you can do is to not have any documents, period. Don't have a last will and testament. Don't have a trust. Don't do any beneficiary designations. What I tell people is, if you want to punish your family from the grave, if you want to give them a hard time from the grave, don't have an estate plan, because it will be stressful, it will be time-consuming, expensive, and miserable, okay? So way number 1 is to go through the court system without a last will and testament. Very expensive, very time-consuming, can be very stressful. Also can open the door to a lot of arguments, okay, between family members. Way number 2, the second best thing that we can do is to have a last will and testament. A lot of you probably have a will, or at least know what one is, and it's a pretty basic document. I consider it to be one of the fundamental building blocks of estate planning, where in this document we're appointing the person who's going to handle our estate when we pass away, and then we're going to name beneficiaries. These are the people who will receive our estate when we pass away. Now, a last will and testament does go through the court system. A lot of people think that it helps you avoid court. It does not. The purpose of a will is to take it through the court system so that executor named in the will gets the legal authority from the judge to do their job, okay? However, the will goes through the court system quicker and in a less expensive manner and in a quicker manner than not having a will. So it's much better than not having one. I call the will the Model T Ford of estate planning. It's kind of that good old-fashioned document that's going to get us from point A to point B quicker than walking, but it's not modern. You're not going to have AC. You're not going to have, music to play. You're not going to go very fast. It's going to be bumpy, but it's better than walking. Now, what's the next best thing that we can do after having a last will and testament to be able to pass down our estate? The next best thing is called beneficiary designations. And this is where you can, for example, let's take life insurance as an example I think everybody can relate to. When you pass away, you have named beneficiaries who get the life insurance money, right? If you have a $1 million life insurance policy and you name your spouse as the beneficiary, your spouse is going to get $1 million when you pass away. So if that weren't the case, why would you have insurance? You wouldn't. But we have it because we have beneficiaries who get money when we die. That beneficiary designation, a lot of people don't know this, can be done at any bank, any financial institution in the United States. So whether it's your checking account, your savings account, mutual funds, a CD, IRAs, 401ks, all the different financial vehicles and types of accounts that we have, you can always go to your institution and you can request to do a death beneficiary designation, and you can leave direct beneficiaries. What that means is that when you pass, these individuals are not going to have to go to court to get access to your funds. They simply get your death certificate. They take their ID to the bank, let's say. It could be Bank of America, Merrill Lynch, Edward Jones, Wells Fargo, doesn't matter. And then the bank gives them immediate access to your account because they verified you're deceased. They have that person. They have that person's information on file as the beneficiary, and presto, you have immediate access to the funds. Don't have to hire an attorney. Don't have to go to court. So that's wonderful for financial accounts. Now, what about real estate? How can I avoid court and pass down my real estate? Well, until about 6 years ago in the state of Texas, you had to have your real estate in a trust. If your real estate was not in a trust, it was not passing, it was going to have to go through the court system to pass to the spouse or to the next generation, okay? But about 6 years ago, our state legislature allowed use of a device called a transfer on death deed. And this is similar to a beneficiary designation. It's a deed where you name beneficiaries who you want to become the owners of your property, your real estate, after you pass away. That's put on file with the county where the land is. So if you're in Dallas County, it's Dallas County Land Records. If you're in Collin County, it's Collin County Land Records. When that person passes, the family simply has to file an affidavit of death and a certificate of death with that county, and the beneficiaries immediately are entitled to that property. They did not have to go through the court system, okay? Now, like I said, we can accomplish that with a trust, which we're going to talk about next. But this is a less expensive way of doing it. A lot of families that were, good, solid, middle-income families, they didn't want to spend the money on a trust. They didn't see any other reasons for them to have a trust. Then when they would pass, and they owned a home, they owned land, their families would have to go through the court system. And this device allows us, in a more cost-effective manner, to avoid court than the expense of having a trust. Now, what about our automobiles? Okay, so if I pass away, I have title to a car, and say a car and an RV. How can I pass that down without going through court? The Texas Department of Motor Vehicle has in-house beneficiary designation forms. We have a stack of them at our office. I give them to all of our clients. But for you guys, if you work with other attorneys, or if you don't have an attorney, then you can get that directly from the DMV. And you fill it out, you leave a death beneficiary, and when you pass away, your beneficiary takes, again, your death certificate, a copy of the title, and their driver's license to the DMV office, and they can immediately transfer title to become owner of the automobile. So that is how we can avoid the court system using beneficiary designations. Now, the fourth thing that we can do, and the most powerful advanced estate planning document that we have in Texas and in our country, is a trust. And I'm going to be talking about a living revocable trust, okay? A living revocable trust means that we can revoke the trust. We can change the trust anytime we want to. It's a very fluid and flexible document. but it allows us to avoid probate court. Period, end of story. If our assets are held in trust, they do not have to go through the court system. Now, you might say, well, that's great, that's wonderful, but why would I get a trust if I can already avoid court just doing beneficiary designations? And the reason is a trust can do other things too that nothing else can do. And we're going to look at some of that. But a trust can help us avoid the federal estate tax. A trust can allow us to treat beneficiaries different, meaning I don't want to leave money to my 18-year-old or 19-year-old son. I want to wait till my son is maybe 25 or 30 to give him money when he's more experienced, mature in life. A trust allows us to leave money out into the future. It allows us to get super creative with our beneficiaries in when and how they'll receive distributions. Sometimes people will make it contingent upon certain things, like, you've got to get a GED or you've got to get a college education first. Things to motivate people to maybe kind of progress in life before they get their distribution from the estate. Okay, so, and we're going to be looking more at that, but a trust is the most powerful document that we have to pass down an estate to the beneficiaries, and it allows for complete and total court avoidance. Okay, now planning mistake number 3, no plan to avoid family arguments. So one of the main things I hear in my office is I want to set things up so that my kids don't argue when I go, or particularly blended families. Blended families can be a big red flag, guys, for needing some really good comprehensive estate planning. I don't want my kids arguing with their stepmom, my wife, or I don't want the stepkids arguing with the other set of stepkids. Make no mistake, we see very serious bloodbaths in the legal system at times between family members, traditional family members, blended family members, all sorts of family members. After the parents pass and there's money there on the table, the knives can come out and people can get ugly. So the more thorough and comprehensive you are with your estate plan, the much more of a chance we can avoid family arguments. Now, every now and then there's that person in somebody's family that just wants to fight and argue and cause problems, so we can't always stop everything, but I think we can cut out about 80-85% of those arguments with good, thorough, comprehensive estate planning, okay? So it's very important, especially for blended families too. Planning mistake number 4, this is where I was telling you about how with a trust, we can do a lot of different things that legally that we can't do with any other legal device. So divorce protection, remarriage protection, lawsuit protection. These are things that I'm happy if you want to come into my office and see me. At some point, I can go into great detail about these things. But I'll just kind of tell you briefly about remarriage protection. Okay, this one's just fun to talk about because I've seen this happen several times in my law practice. Remarriage protection is when I have a couple that sits down and they say, this is very simple. We're 62, we have 2 kids, we've been married 40 years, everybody's healthy and no drama in our family. So when I die, the husband says, my wife gets everything, and then when she dies, everything will go to the kids. Very simple. But I have to introduce the idea. What if, sir, what if your wife passes first and then you do what? Get remarried potentially. What can happen? What can happen is a new spouse can work their way into the estate plan very easily, okay? It's not hard. It's go to the attorney, tell them to amend the trust. Go to the attorney, get a new will, put me in there. And when we see this in our law practice, it's a problem. We have upset adult children. Normally it's their father who, it's a man who spent most of his life married to one woman, lost his wife first unexpectedly, quickly got remarried because that's all he knows how to do is to be married, and his kids are not happy. And they accuse the woman of being a gold digger and a manipulator, and I've seen this numerous times in my law practice. The way around that is to put some provisions in your trust while you're both alive and well that can help prevent a lot of this, okay? Where we can lock things down after the first spouse passes so that we can avoid new people after the first spouse dies working their way into the estate plan. Sometimes it's caretakers for a senior. We've seen lots of strange things and people getting very manipulative when they kind of smell blood and somebody's older and they know they're emotionally vulnerable. They sometimes get manipulated into doing things they shouldn't with their estate plan. Planning mistake number 5. So we're on number 5 here. This is people who have no retirement plan protection. And now I'm not talking about protecting your retirement plan while you're alive. That's between you and your financial planner. I'm talking about after you die. When somebody passes away right now in 2021 and they leave behind retirement assets that we have to pay income on as we withdraw, the law says now when it goes to the next generation, not the spouse, but the next generation, that all the money has to be withdrawn within 10 years, okay? So a frugal person, or maybe a frugal is not even the best word, a sophisticated, smart person, I'll say, would withdraw that money evenly over the 10-year period to minimize taxation exposure, to stay in a lower tax bracket, pay less taxes. However, there's always those antsy, undisciplined, people who just beneficiaries that they just want every penny as soon as they can get their hands on it, right? And through a trust device, we can not allow them to do that. We can tell them, you're going to get 10% a year for 10 years, and that's that. You can't get any more because we're going to minimize taxation, and I don't want you squandering all the money, in 2 weeks. So things that we can do there to really help out. Planning mistake number 6, no legacy protection. Just quickly, at our firm, of course, a lot of what we do is focused on money and passing down assets and property, but we have a firm belief that the legacy that we're leaving to our children, to our grandchildren, is much more than just dollars and cents, right? It's much more than, grandpa's car or grandma's house. We're also leaving behind a set of values. We've all been through trial and error in our life, and we'd like for our kids and our grandkids to learn from maybe some mistakes and to heed our advice, our wisdom that we learned throughout the years. So we have actually a notebook, a workbook for all of our clients where they can leave behind a biography of their life and a lot of information about their family tree and family history, as well as, religious values, ethical, moral values that they find to be important. So I think it's a very critical part of an estate plan. Planning mistake number 7, okay? No nursing home protection. I'll just say quickly, you can read the screen there. Number one, 50% of Americans who reach the age of 65 end up in a nursing home at some point. The average stay is about 22 months. The average cost is getting to be close to $7,000 a month now in large metro areas like DFW. So it's getting very expensive. It's a huge, big business, guys. You probably know that, but assisted living, nursing homes, memory care units, huge business these days. We want to prepare for that cost. You do not want to be caught off guard. So many families are. It's, my husband just had a bad stroke. The doctor in the hospital is saying in 3 days he's getting released. He has to go to a hospital, he has to go to a nursing home. He can't come home. How are we going to pay for this? We want to think this through ahead of time. So there's 5 different ways here that we can pay for long-term care. If you want to seek me out, happy to sit and talk to you in detail about all these 5 different ways. But it's not it's not that one's the best and then the other's better than this, and there's not a hierarchy here, okay? It depends on the family. It depends on the circumstances. It depends on the finances. But these different ways that you see on the screen, we want to find which one of those ways is best for your family, and we want to get that plan in place ahead of time, okay? So very important to take into account long-term care because it's getting super expensive. A lot of families lose everything. Planning mistake number 8, I kind of talked about this earlier. Guys, don't make your own estate plans. Please don't be your own lawyer. I'm not my own auto mechanic. That would be really bad. I don't fix my own AC in August when it goes out in my house. That would be bad. Wife and kids would be very frustrated with me. I call somebody who is trained, educated, certified, etc., to do those things. It is the same thing with estate planning. Stay away from the do-it-yourself documents. I know it's tempting because they're cheap, but there's an old adage in life, you get what you pay for. So you save more money in the long run getting it done right. Also get, every 2 years, I say, get a check-in, get a review for your estate plan to make sure things are still on target, things haven't changed. Now, here at the end, let's talk about this quickly. What is a living trust and how does it work? A trust is simply a document. It's white pieces of paper with black ink on it and says a bunch of legal words. But when these words are put together the right way, it can be very magical because what a trust can do for us by holding title to our assets, by having our assets in the trust, if you want to think of it that way, that visual, It allows us to avoid probate court. It can allow us to avoid the federal estate tax. It can allow us to treat our beneficiaries very differently. It can allow us to avoid creditors at times. It can allow us to have the divorce protection, to have the remarriage protection. A lot of things that a trust can do that no other estate planning advice can do. Okay, guys? And I want you guys also to understand when it comes to a trust, a revocable living trust, okay, revocable, it's a very fluid and very flexible document. It's, you can change it, you can amend it, you can do away with it. Your assets are not stuck in there. They're not frozen in that revocable trust. You can sell things, you can refinance things. It's a very, very fluid and flexible document, okay? Doesn't mean it's for everybody. But along those lines, I want to encourage you guys, I do offer a complimentary initial consultation for up to an hour for any individual or family. So I want to let all of you guys know that if you'd like to come see me in one of my offices, or if you prefer, maybe if you're on the east side of the Metroplex and you'd prefer to do a Zoom meeting, we can do a Zoom meeting. Happy to do that. But take advantage of that consultation. I talk to a lot of people in DFW right now who have moved in from out of state in the last few years. So I've done a lot of out of state estate plan reviews, a lot of older estate plan reviews. So don't be ashamed to walk in with your will from 1988. It's okay. I've seen it 100 times. And we will just sit down with you. I will sit down with you personally. We'll take a look at what you have, and we'll see where we can get you. Kind of present the options of how you can get in better shape with your estate plan, and then from there it's just simply your decision to make. So I want to encourage all of you guys to take advantage of that. Let's have our estate plan done right. Let's have it done relatively soon. Then you put that behind you. You review it every 2 years, and you don't have to think about it anymore. Okay. Thank you guys so much for joining us today, and hope to see you guys soon.